Good morning and welcome everyone to today's Medicare appeals process, what you need to know session. This webinar is geared towards all Part A provider types and it is scheduled for 1 hour. Just a few housekeeping items before we begin today's session. We've been using this updated version of GoToWebinar for a little while now, but just in case you have any issues, I did put the link to the GoToWebinar attendee guide in the chat. So that'll help you out if you run into any issues using the GoToWebinar panel. I also want to note that closed captioning for this session can be turned on or off using the CC button at the bottom right of your GoToWebinar panel. The closed captioning is not always going to be 100% accurate, and that does tend to have some trouble with acronyms or specialized terminology, and those are common in Medicare. So if you need to look up an acronym, we do have an acronym search available out on our website. If you go to www.ngsmedicare.com, you'll select resources and then tools and calculators, and then the acronym search will be available for you right there. And then you can also find the PDF version of this presentation under the materials section in the upper right-hand corner of the GoToWebinar. It looks like a document with a little paperclip on it. It says materials. And in that materials, you'll see a PDF version of today's presentation, as well as a one-page document that's got some more information for you about different educational events or how to access educational events and some other helpful information. If for some reason you can't get to the PDF version in that materials section, if you go out to our website, www.ngsmedicare.com, and go to the events, you'll be able to access a PDF version of this next to the event title for today. If you access it after the session is complete, you'll want to choose past events in order to see today's session name and the PDF attached to it. You're now seeing our standard disclaimer, and this disclaimer just states that although every effort has been made to ensure the information in our presentation is accurate at the time of publication, the Medicare program does change often. Providers must proactively stay compliant with all Medicare rules and regulations. And this slide does include a link to the CMS website, which, in conjunction with also the WellPoint Federal website, will keep you up to date with valuable resources. And just keeping an eye on both those websites to look out for any updates will help you ensure your compliance and optimize your participation in the Medicare program. Attendees are prohibited from recording any WellPoint Federal Education events. So this is just to ensure that you access the most current and accurate information. And this policy does include the use of AI assistant recording tools. And the objective for today's webinar is just to give attendees the knowledge and resources needed to successfully navigate the Medicare appeals process. My name is Jessica Nickerson, and I'll be presenting today with Janine Gambos. We are both Part A provider outreach and education consultants. And then just quickly reviewing today's agenda, we will be going through the appeals process, the appeals levels, and then we've got some resources for you. And then any time available at the end of today's session will be used for questions that you have on the material that we have covered. The question box will be open and available throughout the session. Just note that your question may be answered by the material as we continue, so you may want to hold on to it until towards the end. Please note that we cannot answer any questions on specific claims or appeals in this session, as these usually require additional research as well as contain PHI or PII. So we ask that you direct any of those specific questions to our provider contact center. And also please ensure that when you do ask a question that you do not include any PHI or PII in the question box. All right, so getting started for today, we are going to review the appeals process. So, starting out, we're going to talk about what is an appeal. So, an appeal is an action that you can take if you disagree with Medicare's coverage or payment decision on most processed claims. So, a processed claim is considered an initial determination by Medicare, and it results in either a full or partial payment or a denial. And the purpose of an appeal is to ensure that your claim is correctly processed. So, both Medicare providers and beneficiaries have the right to appeal a claim determination made by WellPoint Federal. So, as a provider, you can identify if the claim is appealable by reviewing the reason for the claim or line item denial. And the remark codes on your remittance advice will indicate if appeal rights exist. So, for example, if you see code N210, it means that you may appeal this decision. If you see N211, it says that you may not appeal this decision. Or MA130 means that your claim contains incomplete and or invalid information and no appeal rights are afforded because the claim is unprocessable. So in that situation, you'd want to submit a new claim with complete or corrected information. And beneficiaries can also see if something is appealable on their Medicare summary notice that they receive. It'll let them know if there are appeal rights for that claim. So, speaking of beneficiaries, an appeal can be submitted by either a Medicare provider, a beneficiary, or an authorized representative. So, even though some parties may pursue an appeal on their own, others may want help or need the expertise from someone else in order to submit an appeal. A party may appoint any individual, including an attorney, their family member. They can hire someone to act as his or her representative at any point in the appeals process. And they would just complete this appointment of representative form or the CMS 1696. And you would submit that to WellPoint Federal at any point in the appeals process, along with your appeal. So the appointment of represent res- the appointment of representative, or AOR, as we'll refer to it going forward, is valid from 1 year from the date that it was signed by either the party making the appointment or the person who's accepting the appointment of representative, whichever of those is later. So there are some issues that we have found with AORs when they're being submitted, and there are some common reasons that we've compiled why they would not be acceptable or they would be invalid. So one of those is that the AOR is signed or dated over a year prior to the submission of your appeal. The AOR is missing a signature. The AOR is missing the name of the person being signed as a representative. On the next slide, I'm going to show you an example of the form, and you'll be able to see where these things are so I can point that out a little closer. Or the signature was there, but it wasn't dated. So we have to have all of that information in order to consider it a valid AOR and be able to process with it. So here's an example of an AOR, and this one happens to be invalid. And the reason being is that the redetermination was submitted for review on February 26th of 2025, but the AOR was signed by the appellant as well as the representative on January 3rd, 2024. So it's invalid because it was signed greater than 1 year from the date that they submitted the appeal. So here on the form, you'll see it has to be signed and dated, and the date on this form cannot be more than 1 year prior to the date that you're submitting your appeal. So once this is aged out, so if you have an appointment of representative made and you've got that dated, after a year has passed from the date on that form, you just need to get a new form. Everyone needs to sign it again and newly date it. So some examples for possible appealable situations include coverage or medical necessity of the items or services that were billed, whether the deductible has been met, or the computation of the coinsurance amount, the number of days that were used for an inpatient hospital, psychiatric hospital, or post hospital extended care, a physician certification requirement, their beginning and or ending of a benefit period, the determination of a limitation of liability provision, any issues affecting the amounts of benefits payable, including if you overpaid or underpaid, as well as prepayment or postpayment probes. So if your claim was reviewed by the CERT or the UPIC or an SMRC or a recovery audit contractor or a QIO and you don't agree with that decision made, those are things that are also appealable. So just to point out that not only denied claims are appealable, but you can also appeal a paid claim. So for example, in these cases where maybe you're appealing that the deductible wasn't processed appropriately or the coinsurance amount was not computed properly, or it's just the number of days that were used, or it was paid, but it wasn't paid correctly. So those types of things can also be appealed. Something that you would not be able to appeal is a claim that has been rejected for Medicare as a primary payer or Medicare secondary payer claims. So if you have a claim that is submitted and Medicare is primary on that claim and is rejected because Medicare should be the secondary payer, you would want to resubmit that claim, correct the primary payer. So you would go out and research who is the correct payer. So you would find out if there is another primary payer and if the claim should be submitted to that payer. So once you have submitted a claim to that payer, you would receive a response for them or a remittance advice back from that primary payer. And then you would need to submit an adjusted claim to Medicare, which would change that claim to Medicare as the secondary payer. If you do your research and you find that Medicare is the primary payer, the beneficiary should contact the BCRC or the Benefits Coordinator and Recovery Center to have their MSP records corrected. So once the MSP records are corrected, the adjusted claim can be submitted to Medicare to process the claim as Medicare primary. Another reason that you would not want to submit an appeal is if your claim is rejected for timely filing. So, federal regulations mandate that timely filing of claims is within 365 days from the date of service on your claim. So, that is usually generated from the from date on the claim, unless you've got an institutional claim that spans dates of service, and the through date would be the date that is used for timely filing calculation. There are only 4 exceptions to claim timely filing. I do have a link on this slide out to the claim timely filing job aid, and that gives you more details about timely filing of your claims. And you would need to review those to determine if an exception is met, and you would submit an adjustment with that detailed information why you're past timely filing. The 4 reasons that timely filing would be allowed to go past the exceptions to that timely filing rule are administrative error, retroactive medical or Medicare entitlement, retroactive Medicare entitlement involving Medicaid, and retroactive disenrollment from a Medicare Advantage plan or a PACE provider organization. So if your claims have been rejected and you feel that timely filing should be bypassed based on one of those 4 exceptions, you'll need to submit an adjusted claim and include the exception reason in your claim remarks. Certain levels of the appeals process require that a claim meet a monetary threshold for it to be eligible for an appeal. So, this is considered the amount in controversy, or AIC. So, that AIC threshold amount is established by CMS, and they can change on an annual basis. So, the AIC amounts are published out on our website as well as on CMS's website. And the way that you would determine if your claims meet the AIC threshold is the amount charged for the item or service should be reduced by any Medicare payment that's already been made for those items or service, and any deductible or coinsurance collected from the items or services. So the amount remaining after it's reduced by that would be the amount that you have available in controversy left on that claim. And as we go through the different levels of appeal, we'll talk about specifically what the amount in controversy is for each level of appeal, so where you need to be. Each level of appeal also has a specific time frame for submission. So these specific time frames will be included later in the session, again, as we move through each level of appeal and review that more closely. But just for an example, the first level of appeal, or redetermination, must be submitted within 120 days of the receipt of your initial claim determination. So the date on your remittance advice. If for any reason you're unable to file an appeal within the necessary time frame, you can request an extension. Extensions are granted by the appeals staff, and they are based on good cause. If your explanation of good cause is accepted, the appeal will be reviewed. Note that if your request for an extension is approved, it does not grant an extension at all levels of appeal. And if you request an extension and it is not approved, your appeal request will be dismissed. And if you agree with, or if you disagree with that dismissal, you can file a request to the next level of appeal. So if you're at your redetermination and we do not allow your request for an extension based on good cause, you can contact the second level appeal or reconsideration within the appropriate time frame based on your dismissal date. We do also have an appeals calculator out on our website that you can use. There'll be a link to it at the end in our resources section of this presentation. And that appeals calculator will help you based on your level of appeal and the date that your decision was received on the prior level. Will tell you how long you have to submit your appeal, or what date you need to submit your appeal by. So we talked about good cause for the extension to be granted on timely filing for your appeal. And good cause includes things like a serious illness preventing you from submitting an appeal, important records being destroyed or damaged, or access to the records were affected by a fire or another event like a hurricane or earthquake or a flood. I'm sorry. If you contacted the for example, the customer service line, and they gave you incorrect or incomplete information about how to file an appeal. If you didn't ever receive your notice of determination or the decision on a prior level of appeal, so that you didn't get access to that in time to submit your appeal timely. If you submitted your request and you submitted it with a good faith effort to get there in the timely filing limit, and it still didn't reach us in time. So, example of it getting mixed up in the mail and it taking 3 weeks to deliver when it should have only taken a couple of days. So those types of things would be considered good cause. There's a larger list here on this slide of some other options, but those are the types of things that they're going to look at to allow for good cause. And it is very important to note that the failure of a billing company or another consultant that the provider or a physician or a supplier has retained to help them with their appeals to timely submit an appeal or other information is not grounds or findings for good cause for late filing. So if you hire an outside agency to process your appeals for you and they do not do so in the proper timely filing limits, that is not good cause for an extension on timely filing. They still are required to submit within the timely filing guidelines. So the MAC does not find good cause where the provider, physician, or other supplier claims that a lack of business office management skills or expertise caused the late filing. So if you aren't organized or you don't have your appeals process in place within your office, that lack of organization there is not also not going to qualify for late filing. All right, so I am going to go ahead and pass this over to Janine, and she is going to go through the different levels of appeals with you.
All right. Thanks, Jessica. Just waiting for the screens to update here. I want to make sure I'm sharing the right screen. Jessica, can you just verify that you see slide 18?
Yes, ma'am, I do.
Okay, fantastic. All right, so let's start our chat on the different levels of appeal. And the first thing that I want to start with is actually straight from CMS's website. And this is really the basis for what we're going to talk about this morning. And we have a similar chart a little bit later in the presentation that contains essentially the same information, but contains hyperlinks for the documents for each level of appeal, which is really great. But this is just a snapshot of what we're going to be talking about, the different levels of appeal, what it's called, the time limit for filing, and what Jessica had already discussed, that amount in controversy and whether there is one applicable. For example, as you can see on this slide, for redeterminations and reconsiderations, there is no minimum amount in controversy required. There's actually only an AIC or amount in controversy for the third and fifth level of appeal. So we'll go through that as we go through each level of appeal in detail. So your appeal level 1 is called a redetermination, and sometimes even myself, I get confused between level 1 and level 2 because the level 1 is a redetermination, level 2 is a reconsideration. So when my brain is not working at full capacity, I get them confused. But level 1, redetermination. Those appeals are submitted to us at WellPoint Federal. The time limit, as Jessica said, to initiate a redetermination is actually 120 days from the receipt date of the initial determination. Now, our time limit to complete our review within the appeals department is 60 days, and there is no minimum amount in controversy. You'll see on each of these similar screens for each level of appeal, we've actually hyperlinked for you the redetermination request form for each applicable level of appeal. So once you download the materials, as Jessica had said, you can either download the materials from your, I still call it an attendee control panel, even though it might look a little different than what it used to, or you can download the material directly from our website. You do have those hyperlinks right in the presentation as well. On slide 21, we just have some tips for your level 1 appeals. And this really goes for all of the appeal levels with some exceptions that we'll go over, but 1 appeal request per claim. So you're submitting 1 redetermination request per claim. You are not submitting 1 appeal for each claim line. Let's say you have 10 claim lines and 3 of those claim lines denied. You are not submitting 3 appeals for each line item denial. You're only one claim per redetermination request form. Now, if you are an NGS Connects user, only the claim that's indicated in the redetermination details is going to be considered. We do a lot, well, when I say we, I mean Jessica, does a lot of webinars on NGS Connects and all of the different applications within NGS Connects, all of the different things that you can do within NGS Connects. There's also YouTube videos out on our YouTube channel for all things NGS Connect. So if you need more information, certainly keep an eye on our training events calendar because we're always doing training on NGS Connects. And again, by we, I mean Jessica. So you're not going to submit additional claims to be considered in the attachments section. We're telling you this because we've seen it happen. So once again, only the claim that's indicated in redetermination details in NGS Connects is going to be considered, and you're not submitting additional claims to be considered in the attachments. So if your appeal request involves an overpayment that's determined through sampling and extrapolation, you're going to want to identify all contested sample claims in one request and state any sampling methodology challenges that were encountered. Now on slide 22, what to include in your redetermination. So this is the minimum amount of information on what we need. So obviously the beneficiary's name, Medicare number, the specific service that you're appealing or item that you're appealing, and the date of service, the name and signature of the person requesting the appeal. Attachments are for additional information. All pertinent supporting medical record documentation. Make sure those signatures are included because that can be a reason that your appeal might be upheld, is missing or incomplete documentation to support your appeal, missing signatures, and so forth. And then Jessica had talked about timely filing, but if you are past that timely filing limit, you want to certainly include an explanation of the delayed request if you're submitting past that time limit. And then when we talk about point of contact information, you want to include someone who will respond promptly to documentation requests. And what this means is that if our appeals department receives an appeal and there's, let's say, one particular signature that's missing or one particular document that's missing, our appeals department, rather than upholding that claim denial, they'll reach out to that contact person and say, hey, can you just send me XYZ documentation? This way it can be reviewed and we can go ahead and process your appeal request. So that's a really nice courtesy that they do. So when you do submit your appeal, make sure you include a point of contact that's going to be able to respond to these requests from our appeals department. So more on documentation here on slide 23. When you're submitting or when you're requesting an appeal, you want to submit a complete medical record. Now, some folks determine, or some folks take this in a few different ways, but I do want to be clear. When we say submit a complete medical record, we're not saying submit a 3,000-page medical record, because when this happens, these 3,000 pages are going to come through electronically, via mail, however you send them in, and then our appeals nurses are going to look at these 3,000 pages and be like, there's no way I have time to go through all of these documents to determine if the information I need is in here. That's impossible. Our appeals, the appeals that come in, the level of appeals that come in are so high that in order to keep up with our time frames to getting our decisions out, if we receive 3,000 pages of medical record documentation per appeal, it's going to be impossible to keep up with our necessary time frames. So when we say complete medical record, what we mean is that you want to determine what type of documentation to submit. Any previously sent medical records are automatically incorporated into your appeals case. Don't resend those. There's a really nice kind of article or section on our website titled "What Documents Are Needed?" And what that includes is a listing of types of services that you may be appealing and suggestions for documentation to submit that may support medical necessity. Now, let's say you are appealing, um, uh, let's say, a surgical procedure for a left knee replacement. I don't know. I just pulled that out of thin air. Now, for whatever reason, your claim denied, and now you're appealing it, and you're trying to determine what documentation to submit to support why this claim should be paid. When you're taking a look at medical records, our medical review department doesn't want to see an appendectomy for this patient that was done 15 years ago. So the reason I'm saying this is because I've personally received referrals from our medical review department, and I use that 3,000-page example, medical record documentation example, because I recently received a referral from our appeals department asking me to reach out to a provider who submitted that much medical record documentation to support their appeal. And our appeal nurses do not have the capacity to go through that much medical record documentation. You're including relevant supporting documents for your particular case. In addition to supporting documents, you want to also include a copy of the decision letter or claim information that was issued at any prior level of appeal, if applicable, and a copy of demand letters if you're appealing an overpayment determination. So we're still on your level 1 appeal. So there's a few different ways in which you can submit your appeal. So once again, we've hyperlinked that Part A redetermination request form for level 1. You can type your information right into that form, or you want to ensure your handwriting is legible. My handwriting is terrible, so if and when I can type right into a particular form, I'm certainly going to do so. But if you don't have that option available, make sure that you are writing slowly and clearly, so once it comes through to us, we can see what you're requesting. You want to complete all areas on the form, include any attachments if more space is needed. Remember that one claim per appeal rule, and attach any necessary documentation. And when we talk about mailing to the correct address, you can see on this slide that for our JK, Jurisdiction K Part A providers, there is a different PO box than there is for J6 Part A, F2HC, and RHC providers. So your JK providers are your New England states plus the state of New York, and then J6 Part A providers are in the Midwest. There's 3 states, and FQHC and RHC providers are kind of all over the place. Those slides actually were included in our pre-webinar slides that we showed before we went ahead and got started today. So make sure you're sending to the correct PO box. So some tips on protecting PHI. So when you're sending your documentation via either FedEx, UPS, USPS, add a cover sheet indicating that the package does contain PHI and include all necessary disclaimers. You want to label your boxes and envelopes clearly, use reinforced boxes, secure with shipping tape, and also confirm that any unrelated information not included, any unrelated information is not included within that package or envelope. So that's obviously tips on protecting PHI when you're sending via those mechanisms that are on the left-hand side of the slide. But that's not your only option, and I'm sure you know that. Your other option for submitting appeals is submitting your redeterminations in NGS Connects. Again, we offer tons of webinars on NGS Connects, So you would obviously log in with your username and password, make sure you don't share it with anybody else within your facility, and you can follow the instructions within the NGS Connect's user guide to submit your redetermination and supporting documentation. That NGS Connect's user guide contains very clear clear but detailed instructions on how to submit your redetermination and supporting documentation. Submit only documentation relevant to the services and dates within your request, and I gave you an example of what not to do with your knee replacement and your appendectomy from 15 years ago. You also want to submit as few attachments as possible by combining multiple supporting documents into each attachment. That one example that I gave you of the 3,000 pages of medical record documentation that we received came in 3 separate attachments. So you can imagine how time-consuming it would be to go through that, right? So on the bottom of the slide, we give you some guidelines. So the attachment maximum size is 100, I think, megabytes each. There are certain file types that are not accepted, and the file name should only consist of letters and numbers and no special characters. All right, another tip, don't submit duplicate requests. Submitting duplicate reopenings or redetermination requests are going to result in processing delays and is also abusive and costly to the Medicare program. You can actually check if you've previously submitted a reopening or a redetermination via NGS Connects by verifying your submission history. Your submission history panel actually displays redeterminations submitted in NGS Connects on or after 2/25/2022. So it's very easy for you to verify if you've submitted an appeal or a reopening in NGS Connects by verifying your submission history. You can also submit your redetermination via ESMD. So ESMD is electronic submission of medical documentation. That's hyperlinked for you at the top of the slide, and it'll take you to CMS's website to give you a lot more information. It's a CMS-developed mechanism for contractors to receive redeterminations electronically via a secure gateway. So maybe another Medicare administrative contractor doesn't have something like we do, like NGS Connects. They can use ESMD, or even if you do have NGS Connects, maybe you prefer ESMD. But that is another way to submit your appeals to us. To electronically submit your redetermination to WellPoint Federal, you can either build a gateway or procure gateway services from a health information handler of your choice. You want to include always the completed and signed Part A redetermination request form for Level 1 appeals, and that should be your first page of submission. So that wraps up your Level 1 redeterminations. Let's get into your second level of appeal. Level 2 is your reconsiderations, your second level of appeal. Your second level of appeal is submitted through your QUIC or your Qualified Independent Contractor, and that's assigned by CMS. There are different Qualified Independent Contractors that are assigned by CMS for different jurisdictions within the United States. The time limit for the QUIC the time limit for you to initiate your reconsideration through the QUIC is 180 days from the receipt date of your redetermination decision. And the QUIC's time limit to complete their review is 60 days. There is also no minimum amount in controversy here, and just as we did for the first level of appeal, we've hyperlinked the Medicare reconsideration request form at the bottom of slide 29. Now, I did mention that there are different QUICs or Qualified Independent Contractors depending on your jurisdiction, and this is where we're going to review that. So for your Jurisdiction K Part A providers, your QUIC is C2C Innovative Solutions. Their website is hyperlinked for you at the top of the slide. They do have a phone number for questions, and there's different ways that you can submit reconsiderations to C2C Innovative Solutions. You could use the U.S. mail. We've provided their address. Secure fax, and the fax number is listed, and they also do have their own appeals portal that you can use. Now, so that was for Jurisdiction K Part A providers. For your Jurisdiction 6 Part A and your FQHC and RHC providers, your QUIC is Maximus. Their website is hyperlinked for you at the top of the slide. For questions, for your J6 Part A, FQHC, and RHC reconsiderations, there is a phone number. There's different ways also that are very similar to C2C Innovative Solutions. You can submit your reconsideration to Maximus via the U.S. mail. Their address is there, secure fax, and they also have their own appeals portal. Now, on slide 32, this might look familiar. You can also submit your reconsiderations in NGS Connects. So when you access NGS Connects, once again, you're signing in with your own unique username and password, again, not to be shared. Follow instructions in that NGS Connects user guide to submit your reconsideration and supporting documentation. Once again, you're only submitting documentation relevant to the services and the dates within your appeal request. Same guidelines as your Level 1 appeal. You're submitting as few attachments as possible by combining multiple supporting documents into each attachment, and the attachment requirements are the same as we discussed for your Level 1 appeal. All right, moving on to Level 3. The third level of appeal is with the ALJ. ALJ meaning Administrative Law Judge. The time limit to initiate an appeal to the ALJ is 60 days from the receipt date of your reconsideration from the QUIC. Their time limit to complete their review is 90 days, and there is an amount in controversy here. These amounts in controversy, they're updated on an annual basis. So for 2026, the amount in controversy is $200. And as we have for the first and second level of appeal, the request for an ALJ hearing or review of dismissal form, ONHA 100, that is the appeal form that you're going to use for your Level 3 appeals. Quite some time ago, and I cannot verify at this time if it's the same, but in speaking about the time limit to complete review, there was a time where their 90-day time requirement was not being met. Their appeal levels were very much backlogged. So I don't know if the same holds true for the current days, but there was a time in which there was a little bit of a backlog there. And we'll talk about how you can check the status of your appeal with the ALJ in just a few minutes. But first, because there is a minimum amount in controversy here, let's talk about aggregating claims to meet the threshold. So to meet the threshold amount of $200, two or more claims previously reconsidered by the QUIC can be aggregated in the request for an ALJ hearing. Can also include both Part A and Part B claims. And if you give me just a second, my computer kind of froze. Okay, so can include both Part A and Part B claims. This aggregation of claims can be done by an individual appellant or multiple appellants. So when we talk about individual appellants, all aggregated claims must involve the delivery of similar or related services. When you have multiple appellants, all aggregated claims must involve common issues of law and fact, and that's verbiage directly from the manuals, right? Your request for an ALJ hearing must be properly filed, as we mentioned, within 60 days after the receipt of all appealed reconsiderations. You want to list all claims to be aggregated, and you want to also include the reasoning as to why the claims involve common issues of law and fact or similar or related services within that request as well. So this is what I was talking about just a little bit ago here on slide 35. For Part A and FQHC, your ALJ Level 3 appeals are done through the U.S. Department of Health and Human Services, Office of Medicare Hearings and Appeals, which is a mouthful, or OMHA, O-M-H-A. So for questions on the ALJ process, there's a phone number and an email address that you may use. Ways to submit: you can submit via U.S. mail, and the address is located right there for you. And they also have their own OMHA e-appeal portal that you can use. Now, back when there was a huge backlog of the Level 3 appeal decisions, we advertise this quite often, where providers could check the status via ALJ Appeals Status Information System, or AASIS. You can still use that, of course, to check the status of your Level 3 appeal. Your Level 4 appeal is via the Medicare Appeals Council. It's through the DAB, or the Department Appeals Board. The time limit to initiate an appeal to the DAB is 60 days from the receipt date of the ALJ decision, and their time limit to complete their review is 90 days. Once again, no minimum amount in controversy, and the request for review of the ALJ Medicare decisions or dismissals, the Form DAB 101, is hyperlinked for you at the bottom of slide 36. Some more information on slide 37 on your Level 4 appeals. So once again, Department Appeals Board, Part A and FQHC providers. There is a hyperlink at the top of slide 37 for appeals to the Medicare Appeals Council. For questions on your DAB Medicare appeals process, there is a local and toll-free number that you may use. And similar to other levels, there you can submit your DAB Medicare appeals via U.S. mail. There's an address there. Via fax, there's a fax number there. And then at the bottom, there's also an e-file option that is hyperlinked for you. All right, Level 5. Level 5 appeals are through judicial review. So they're handled through the federal U.S. District Court. The time limit to initiate your judicial review appeal is 60 days from the date of the Medicare Appeals Council Departmental Appeals Board decision. Their time limit to complete their review, well, there is none, right? This level is so high through the U.S. District Court, the federal U.S. District Court, that there is no time limit for them to complete their appeal. There is a minimum amount in controversy for the Level 5 appeals. Hopefully you never have to get to this level, but this amount also is updated annually. It's $1,960 for 2026. And different from all of the other levels of appeal, there is no official form required. However, we do suggest submission of all other forms for appeals, Level 1 to 4. To include in your Level 5 appeal, but there is no particular form that is required there. On slide 39, we're reminding you that because this Level 5 appeal is submitted through the federal U.S. District Court, you're not sending these to us. You're not sending them to WellPoint Federal. You're filing the Level 5 appeal, your Level 5 appeal, in the appropriate district court for the United States. So the judicial district in which the appealing party resides, or where the individual institution or agency has their principal place of business. That's where you're going to file for your federal U.S. District Court Level 5 appeals. And as promised on slide 40, we shared a similar slide at the beginning of this section where we're talking about the appeals level, again, this is a very similar slide, but you can maybe pull this slide out and save it to your desktop or wherever, although it is going to need to be updated on an annual basis, and we complete these webinars, conduct these webinars, usually on a quarterly basis anyway. So you have in the first column your appeal level 1 through 5, your monetary thresholds or your AIC amounts for 2026. The time limit for filing is in the third column, and then any forms are hyperlinked for you in the fourth column, with the exception of that fifth level of appeal, because no official form is required there. So hopefully that's helpful to you. Some appeal tips. We're wrapping up here, and we just want you to remember that you need to be timely and valid in your submission. So Jessica talked a lot about timely filing and some exceptions to the rule, and whether or not those exceptions are valid. Be appropriate in your submission, meaning don't submit duplicate requests, because that's going to bog down the system. Don't submit 3,000 pages worth of medical record documentation. You want to be patient and wait the allotted time frame for us to make our decision, or for any other level of appeal. For example, the ALJ or the Department of Appeals Board, be patient and wait for them to make their decision. Don't submit duplicate appeals. Be forthcoming for future contact, meaning include that point of contact that we discussed, because if there's something fairly small and insignificant that we can reach out to you about to get documentation to support your appeal, we want to do so. Rather than upholding your appeal, we want to be able to overturn it for you. So make sure you include a valid point of contact. Be prompt, meaning be timely, and be thorough, meaning submit the documentation that's going to support your appeal request. Don't submit 3,000 pages. That's not what we mean by being thorough. We mean complete those forms accurately and fully. Make sure you're submitting documentation specific to your appeal that's going to support medical necessity, and stuff like that. So those are just some tips that our appeals department wanted to share. I'm going to run through some resources and references, but not in detail. These are for you to review at your convenience. We have some CMS references and resources on slide number 43, including some MLN matters booklets and fact sheets at the bottom of the slide. We have some CMS Internet-only manual references, so this is a really great slide full of appeals information. WellPoint Federal resources and references. So we have a whole appeals section on our website. That's going to be your first hyperlink. For specific information about the levels of appeal and time limits for filing, that's a section within the appeals section, if that makes sense. Appeals forms are directly hyperlinked for you. There's a couple hyperlinks for NGS and the NGS Connects user guide. And then there's also some news articles. Appealing a denied claim is really helpful. And then providers using NGS Connects submitting appeals and supporting documentation. So those are two helpful articles right on the WellPoint Federal website. As Jessica mentioned, the appeals calculator. So on our website, which is hyperlinked, if you click on resources, tools and calculators, and then appeals calculator, that's what Jessica was referencing earlier, where you can enter the applicable information and it will calculate the due date of your next level of appeal. Slide 46 is just a standard disclaimer that we, listen to me, a standard resource slide that we include in each and every one of our presentations, where to find us online, how to sign up for email updates. These are directly hyperlinked for you. Some information on YouTube. I talked about the fact that There's many NGS Connects YouTube videos out on our YouTube channel, and we're always working on adding more content, knowing that you don't always have the flexibility to attend our webinars when we offer them. And the same thing goes for Medicare University. Medicare University was revamped in the past year or two. Our educational content, our CBT, computer-based training courses, look very different. They're much more interactive. You can start a training, and then if you need to take a break for a few hours or a few days, you can come back in and finish it at that time. Again, realizing that not everybody has a super flexible schedule, and you can't always attend our webinars when we offer them.